first. So my name is Josh Floyd. I'm an attorney at Jimenez Law Firm, and welcome to the consultation. It's a live stream that we do every Friday at noon, where we talk about issues, family law issues. People send us in questions and post questions on Facebook. We try to answer the ones that we can. Don't take anything that we say here today as legal advice. It's just kind of a roundtable discussion for us to sit around and talk about some issues, hopefully give you some insight as to what goes on in attorneys' offices behind the scenes, and help you understand some of the issues that come up in family law that we have to deal with on a day-to-day basis. Each fact pattern is different, and you'll hear a lot throughout this that, one little fact in a fact pattern could change our entire opinion on cases. So don't take it as legal advice. If you have issues like this, then hire an attorney in your area that handles family law. So, James, go ahead.
If I have removed my son's father from child support, can I put him back on in Texas? Tag backs.
Yes, good question. Remove my son's father. So presumably, I think that means agree to no child support, right? Yes, you can. The burden's a little different than it normally would be. So generally, to make a modification in child support, you have to show that there's been a material and substantial change in circumstances, or if it's been 3 years, you're 20% or $100 difference in the amount of support. And so now to put him back on child support, if you've agreed to no child support, you're going to have to just show the material and substantial change burden. So like what's changed from the time that you agreed to no child support to now that now would require child support when it would not have required it when you agreed to no child support. That's the burden anytime that you deviate from guidelines. So, whether you go higher or lower, or in this case, no support. So yes, you can. How and whether you would be successful is really, really fact intensive. But that's what you have to do, is compare what it was like then to what it is now and show why support would now be justified. Bueno, any questions about that? What do y'all think? No comments?
There are tag backs, so to speak.
There are tag backs for sure. Although it's more difficult. Okay. Well, yeah, I don't think there's much to that question. I know if Christina were on here, we'd be going down subject matter jurisdiction in Arkansas, kind of go down that road, but I don't want to take it there. I don't care about Arkansas's jurisdiction.
I don't think anybody wants to talk about jurisdiction.
Certainly don't.
All right. I'll ask the next one, I reckon.
Yes, sir.
Julie. I don't know who's going to answer this question. Okay, we'll see what happens. Julie, how possible is it for a father to request a change to the possession order from the standard first, third, fifth, and holidays to 50/50?
Depends which firm you hire. I mean, let's start there.
True.
I mean, there's a million factors that go into it. It's possible. It depends where you're at. It depends on the factors of your case, what's going on with it. I guess we can talk about burdens of proof. If for an order to change and be modified, there has to be a shift. Something has to have changed once you have an order in place. So there has to be a material and substantial change in order for an order to be modified. If that's the case and you meet one of those guidelines, then it's possible.
So let's talk about the kind of shift towards 50/50 now, right? Because we've been getting a lot of 50/50 questions, and we're starting to see 50/50 possession a lot more and more and more. Mm-hmm. Obviously, in some courts more than others, right? Some courts are still dead set, like no, right? And some are, every time I get a chance, I'm doing 50/50. Well, let's start this way. Julie, what is 50/50 possession?
50/50 possession is exactly that. 50% of the time with mom, 50% of the time with dad. Usually looks like a week on, week off. I think that can change. I've seen agreements where it's like 2 weeks on, 2 weeks off, but most time it's a week on, week off.
Okay. And so the last legislative session, we saw a shift from the standard possession order to where it included the standard possession with elections for parents that reside under 50 miles, right?
Mhm.
Why do you want to explain what the elections are?
I break it down to basically say it adds Thursday, it just adds additional time in there. So it's the first, third, and fifth, but then you get some additional time.
Right. So it takes your weekday visit, which would be Thursday. And instead of being from 6 to 8, you would pick up from school on Thursday and return to school the following Friday. And then your weekend visit, instead of being Friday at 6 to Sunday at 6, you pick up from school on Friday and return to school the following Monday, right? And so that just went into effect a couple years ago to where now that's part of the standard possession order. It's always been an option, but now it's just part of the standard possession order.
So I guess the thought here, when moving to 50-50, at least from what I've seen, it's usually, hey, kid is spending a lot more time either at mom's or at dad's, or even in some situations, they're actually living together. I mean, and so in doing so, outside of those significant situations, I don't really see too many other occasions when we're looking to shift that situation from standard to 50-50.
So as of right now, both of you are lucky enough not to have kids. I won't be able to say that for James here in a couple months. But what are your thoughts on 50-50? Like, good thing, bad thing?
I think there has to be some real co-parenting for it to work. If there's amazing co-parenting and it's the same type of environment, I think it can work. I will say once you hit school, I think a lot of times it is hard. It's hard on the kids. And so it's something you have to be aware of. And if you're not communicating and not working, it's very hard to make 50-50 work out.
And yeah, I mean, if I'm being honest, I dislike it. I think it disrupts the kid's schedule, and I think the kid is going to have to try extremely hard in order to be successful. On a personal tip, but that's just my own bias, but I'm sure it works for some people.
So to devil's advocate that or not, or to devil's advocate that, sorry, I was reading the comment, devil's advocate that. So the difference in a 50-50 possession schedule and the standard with elections, right? How much time are we talking about?
Honestly, not a lot anymore with the elections. It's much closer with the elections.
Right. So the elections have been presumed, right, to be in the child's best interest anytime standard possession was ordered. So elections have been around for a while, right? But now they just kind of incorporated it into the standard possession order. So standard possession with elections has been around for quite some time. And if there's not much of a difference in expanded standard and 50-50, what's the issue? Right? If the child is still changing homes the same amount of times, right? Or less.
I think part of the issue comes with when they're changing and how they're changing. And in some ways, 50-50 may be better than that instead of the Thursdays at that point. But I think it depends on the individual situation, because I mean, I've had amicus cases where a kid does much better in school with one parent than with the other, but he or she really enjoys outside school time with the other parent. So sometimes that plays a factor into how it works out, which is why I think it is so case specific.
Yeah, and we had a prior client, Corey Kano, long before you guys were here. But I remember the case. And they're saying that 50-50 from 9 or 10 years ago is working great. And so I think that's one of the exceptions when you can really co-parent it. I think 50-50 is best for the kid, hands down. If the parents can co-parent, right? Spend an equal amount of time with both parents. And I think it's more that the parents can co-parent that's what's best for the kids, right? I mean, so I think it's a great thing. I think that it is difficult in a lot of circumstances, particularly early on when the relationship ends and there's a hostility there and, I'm trying to jab at you every time I get a chance. But so we're seeing the shift to 50-50. And it also depends a lot on the court, right? I think we talked about that. So some judges you ain't getting it. Okay, who wants to ask the next question? I'm tired of talking.
I will. Can the Attorney General take child support owed out of my son's commissary since he is incarcerated? My son is incarcerated and is unable to pay child support, and he also owes back child support. He was told that if he owes child support, that the Attorney General will take it from his commissary. Also, is the attorney needed to file for a modification to the child support order? James, what do you think?
This one. So will they take it out of his commissary? It's sort of discretionary, but can they? Yes, they can, which is kind of tough, right? Because, yeah, I mean, that is used for your everyday food and just basically your currency while you're inside. So it's a difficult situation, but they can and will, if they decide that is the most appropriate means to get that child support. Now, with regards to the modification, you don't have to hire an attorney. You can go on the website and you can look up their child support section, and then you can download the paperwork necessary to file that modification for the child support. There are other ways that you can go about paying that child support. For example, if this is your son, mom or father, if this is a concern for you all, y'all can pay on his behalf, arrange a different sort of payment schedule so the gentleman can continue to eat and move about in the marketplace while he's inside.
So short answer, he needs to take that commissary and turn it into soup real quick.
right. Quick, fast, and in a hurry. Ho-hos and wham-whams. It's a thing.
Didn't we have this question last week? Did y'all watch last week? Were y'all on last week? I don't remember.
We weren't on.
I wasn't on last week.
I thought we had this question last week, or we've had it recently anyway. And Christine and I discussed whether the child support obligation should continue, even though he's incarcerated.
It doesn't stop living, And I think it would set a dangerous precedent anytime you get child support orders on you, you go out and knock somebody over the head to avoid said charges.
You get put in prison to avoid child support?
Hey man, people do some wild stuff.
I guess so. Okay. So Sarabia says he finally caught Christina not on Facebook. So we can answer the question. Julie, how are babies made?
Oh, the stork comes in and they bring them in at night and set them on the doorstep. It's really a cool process.
That's how they're delivered.
Only animal in the world that will deliver a human baby.
Right, but how's it made? So the stork just delivers it, right? But how does the baby itself come into existence?
I think you'd have to talk to God about that. I don't know.
Okay, James, they said speak to you.
I guess I am God's messenger. So
this is dangerous.
Now you see, my brothers, my sisters, once we all come together and realize that he has a plan for each of us, right? And that plan, part of which is to be fruitful and to multiply. Now, a lot of you were turned off of multiplication from your early introductions in mathematics. I'm gonna tell you like this. When two people love each other just enough, and y'all know the rest. I mean, come on now.
Oh, no.
I mean, it is Rabia. He may not.
This is a family show. And then, doesn't he have children?
He's got children he supports, yeah.
And I know it's not with commissary either. But,
all right, so Rob, you got your answer. There you go. I guess falling in love makes babies.
Absolutely.
Scary.
Tell him James Palin told you.
I wonder how many kids I've got in with all the women that are in love with me. It's crazy. Okay, next question.
All right. Can my ex refuse to sign a final custody court order? The judge declared my ex and I have 50-50 custody. Since my son's father makes slightly more than me, he does have to pay the difference in child support. He is furious about this, but he and I both verbally agreed to it all in court, and it was set to be drafted and finalized. My lawyer made a final draft and submitted it to my ex and his lawyer, and he refuses to sign it because he does not want to pay. Either way, he has to pay child support, right? The judge ordered him to, and we agreed in front of the judge, ? He should have already made 2 payments by now, but hasn't. Isn't this contempt of court? Mr. Floyd, what do you think?
I feel like we've had a question similar to this recently as well. All right, so let's start with the first question, which was either way, he has to pay child support, right? The answer is yes, he does have to pay child support. Even if he doesn't want to, or if the order is not signed by the judge, he'll still owe for the months that he hasn't paid. He should have already made 2 payments by now. Isn't it contempt? It's a violation of the court's order, right? But he can't be held in contempt because the order is not signed. So what needs to happen, if he's not going to sign the order, his attorney's not going to sign the order, your attorney typically would file a motion to enter. We'll talk about the motion to enter first. We'll file a motion to enter. Court will set a hearing, and the attorneys will appear. And if there's something wrong with the order, they argue about what's wrong with the order. But regardless, judge will make a decision, and an order will be signed, generally speaking, at that time. Before they leave the hearing, you'll have an order signed. The other way, some counties allow you to do what we call 10-day letters, where you submit the court a copy of the order along with a 10-day letter. And if the other party does not make any objections or formal objections to the court within 10 days, then the judge will sign the order. Either way, you need to get the order entered. But even if it's entered 6 months after the judge said child support was going to start, he still owes for the back support. And so if judge said child support starts January 1, 2022, but the order's not signed until May 1st, 2022, the order will still state that child support began January 1st, 2022. And so when the attorney general gets that order, it'll show a retroactive balance. So still gonna have to pay it. Can't hold him in contempt until the order's signed. But if after the order's signed and he still doesn't pay, then Julie, what do we do?
After the order of contempt is signed?
The order for child support.
Oh, well, then we file a motion for enforcement, and we can file for contempt, assuming the order's been entered and done.
So I know that Sarabia has no idea what that means. So will you tell him what it means?
It means we go in front of the judge and make them do it. Basically say, judge, they're not complying. We show and prove up the case that they are not paying their child support. And at that point, the judge can do contempt of court, which means the judge has a couple of options. Normally, like in the 446, it means you're going to jail for 180 days and up to a $500 fine. So normally on child support, there's a bond set for the full amount of the child support that can help get you out. But you're going to get your child support, or they're going to do 180 days in jail.
Yeah, so you could do criminal contempt, which I think is what you're talking about, was she went to jail, or he went to jail, whoever was violated. That's criminal contempt. You're sentenced to jail for a period of time. There's civil contempt, which was the second thing you were talking about, right? Where you could post a bond for the amount. So basically, civil contempt is once you satisfy the obligations that you failed, then you can be released. Criminal contempt, doesn't matter what you pay, you're in jail.
Right.
So, and you could also get attorney's fees, right? If she filed the enforcement, she could get attorney's fees awarded.
Right.
So,
how often is it that you get a child support awarded if there's a 50-50 custody?
I think it happens a lot. I think there's a lot of offsetting child support. So Offsetting child support, James, you know anything about that?
That's it. There are, that's a Migos reference. Sorry, guys.
Yeah, we didn't get it.
Sorry. So on the 50-50 possession schedule, one party, they're going to be assessed on what they make. So is the other party. And whoever makes the most, you subtract, and that's what they end up having to pay.
So like offsets.
Yeah, it offsets.
I wonder why they call it that. That's crazy. Okay.
And so my question with this guy is what the issue is and why he is now maybe what I'm thinking what happened is that they did not do the child support calculations when they went up in front of the judge and just gave a basic agreement, hey, we're going to do 50-50. And then once they got the actual numbers and he found out he was going to have to pay, perhaps that's when he was looking to back out way. I'm not sure. It just doesn't make a lot of sense, though. Yeah,
like I said, the agreement could have been 50-50 offsetting support, presuming that it would be about even. And it didn't work out that way. Sucks for that guy. Should have done the math. Okay, is it my turn to ask a question? Or James? I don't know. Somebody ask a question.
Will I still have to pay child support if I voluntarily relinquish all parental rights? I had a casual encounter with a woman while I was traveling for work. She recently informed me that she was pregnant. I'm not interested in raising the child. If I voluntarily relinquish all parental rights and she agrees, do I still have to pay child support? I understand the court still needs to terminate the parental rights. That's a good question for Floyd.
James?
Well, I was going to say, do you know you're the father, big guy, before we start jumping to, right? Because casual encounter was not in my definition of baby making. So I'm going to go ahead and do that right now.
That's true. And if she had a casual encounter with you, you probably weren't the first. You may have been. We don't know this sweet little girl.
But yeah, I think that's issue number one. Issue number two, what do you think, Floyd?
So if she agrees to no support, then that wouldn't be an issue so long as the judge finds that that's in the best interest and clear and convincing evidence terminate the parent-child relationship. Do I still have to pay support? So no, if she agrees, then no. If she doesn't agree to terminate the parental rights, then you just signing an affidavit of voluntary relinquishment is not going to do it. You're still going to have to pay support. That affidavit's not going to mean anything. But if she agrees, you should be able to do it. Shouldn't be any issues. There was something else I was thinking about, and I don't remember what it was now.
How can he check if he is the father? How does that look, Floyd?
It's a DNA test. And so have you seen one before?
No, I haven't.
There's like little things that look like DNA and they compare those.
Hey, oh my gosh.
No. So if you're not sure if you're the father, then you can file a petition to adjudicate parentage, request genetic testing, and then you'll know if you're the father based on the DNA test that I was referring to a second ago. Or another option is to do nothing. You can't get a child support obligation if there's not an order, right? And so make her make the move and adjudicate you the father and then get a child support obligation.
Or you could think about this thing for a little bit, right? Because, you know, as someone who is grown enough to make a baby, that a baby needs that support system. And though you may not think it now, but it's possible that you and this young lady form something beautiful between the two of you.
So
yeah, and just, you know, they got to hear it from somebody. And as God's messenger today, I'm going to say,
I think James thinks it's Valentine's.
He does.
You're in the red. James is talking all Cupid. I don't know.
I'm just saying.
Yeah, James is right. But the problem is, if you fall in love, you're gonna have another damn baby to deal with. Right.
Multiply.
Right. And now you're talking about 25% support instead of just 20%.
Or actual support, right? We can come together as one.
More expensive than both of those.
But you get a better tax break. Come on, Floyd. Let's stay on one accord here.
All right, we're gonna be positive today. Yeah. So y'all will fall in love and live happily ever after, and you'll die together. That'll be the end of it. Nobody would care. Greta has a question.
Greta?
This ought to be good. What if I was awarded a home in a divorce, sold said home, purchased another home with the funds arising from the sale of my first home with my ex, but a divorce is imminent? What happens to the new home? She never said she got remarried. So I'm assuming she got divorced and then got remarried and now needs another divorce. I understand that, knowing Greta, right? I could not be married to Greta either. It's kind of understandable.
Greta is a nice woman.
So Greta, as you are aware, I would need to know a lot more facts, like, when the homes were purchased, when you were married, were there debts on it? Can't answer your question. It's ridiculous. All right, James.
Okay. Let's see. If the judge orders my ex-spouse to not use drugs or alcohol while in possession of kids, what does that entail for him? Regarding possession of children in a divorce case, in a divorce petition, I check that I am concerned with the safety of my children and ask that the other parent be ordered not to use alcohol or illegal drugs 24-hour period prior to or during the possession of the children. My spouse has misdemeanor and felony drug charges and some DWIs. So your question is, if the judge orders my ex-spouse to not use drugs or alcohol while in possession of kids, what does that entail for him?
Sobriety.
Yeah.
Pretty much. I was like, if the judge orders it, that's exactly what it means, that they can't use drugs or alcohol. Sometimes we put provisions in that say, like, you can get one random test a year or something like that if you think they are. And if they violate that order, then you're back to filing enforcements and contempts, and depending on how severe it is, possibly getting some emergency relief to keep the child protected, especially if they have current charges. But if they have current misdemeanor and felony drug charges and DWIs, I would also recommend getting an attorney, because you may be able to get a little more than just an injunction.
True that. Okay, so let's talk about these injunctions for a minute. What are the standard injunctions we see? How often do we see these types of injunctions, and what the hell is an injunction?
So we see no disparaging remarks against the other party a lot. We see no alcohol and drugs. We see what we call morality clause that talks about if you are not married to someone and you are in an intimate or dating relationship with them, that they can't stay overnight at the residence when the child is present. And we also see a lot of no discussing litigation. Those are the most common, I think, that we end up seeing every day. And what is an injunction? It is an order of the court basically stopping you from doing something. So the court is saying 100% you cannot do this, and if you do, you are violating my order.
Okay. And the remedy if they violate an injunction you said was an enforcement.
Mhm.
So one of the problems I run into a lot is enforcing these, right? You know, how do I prove that he drank a beer while he was in possession of my child?
And it varies case by case. Sometimes it's statements, sometimes somebody saw him, sometimes it's a photo, sometimes it's just hearsay and you may not be able to.
Sometimes the fool posts it on social media.
We hire private investigators, or attorneys hire private investigators.
Yeah, we had one where they posted on social media at a restaurant with the child drinking. But these are difficult, particularly with drugs, right? Drugs are even more difficult to prove the violation, right? But they're difficult to prove the violations because one, somebody has to be able to see it, right? Or somebody has to have seen it. And then that somebody has to be credible and be willing to come testify for you, because you can't testify to what that person told you. Right. And then we get into this he said, she said stuff. And well, was the child there? Was the child at a friend's house or whatever? So they're difficult to really enforce. But if people follow the order, then it should be helpful. And you had mentioned random drug testing. Julie, what's that look like?
Random drug testing is when you are ordered by the court to go get a drug test. So most courts, I think, have a certain lab they use or trust to get those tests done. Then you literally go and you get for 446 in most courts, I think it's a hair follicle. I don't know if any up in Tarrant use UAs or anything like that, but most courts, I think it's a hair follicle. And so you basically go into the lab, they pull a hair and they test the root of it to see if you're using any drugs.
How far does it go back?
Usually 180 days. Some can do a little more and some are a little less, but I think most are around 180.
And so generally when we see this type of language, the random drug screen language, it gives one party the ability to randomly request a drug screen from the other party. Right? And that other party has a certain amount of time to comply, to appear and submit to the drug screen. Yeah, it's just kind of particularly with somebody that's had drug issues in the past, it's a way to kind of monitor it from a court's perspective, a way to monitor it to make sure they're not using, from the other parent's perspective, a way to catch them slipping in and take more custody, more possession. But anyways, so yeah, cool. Anything else on drug screens or injunctions or April Fools or Sarabia or Greta?
I mean, I think we could write a book on Sarabia.
Good. We probably should one day. All right, Julie, James is chomping at the bit. He wants to talk about dogs.
All right, let's see. Can I get custody of my dog after the divorce? My husband and I recently finalized our divorce. We had a verbal agreement that he would look after our dog until I found a place to live, and the dog would be mine. Now he does not want to give the dog back. We did not write anything about the dog on the divorce paperwork, but I do have text messages with him agreeing. Can I take him to small claims court, or do I have any other legal options to get my dog back? Oh, that's so sad. Custody over the dog. That's hard.
It's really
That's
sad.
the
You
deal.
gave up the damn dog.
What'd you say, Floyd?
You gave up the dog.
Right. I mean, that is tragic. But in the state of Texas, you actually won't be having a possession schedule for the dog. So that's that 50-50 thing we talked about earlier. Doesn't work for dogs or cats or gerbils. I think, Floyd, you have a weasel, right?
A weasel. Yes, I call her my wife. Some people call her a weasel.
I can't set them up. Okay. But in this case, yeah, the state of Texas is going to look at them like a piece of property. So whether you can find that you had the dog before you all got married, or you purchased a dog, or in your case, there was some agreement with regards to where the dog was going to end up, that would certainly help you out. You can modify that divorce I mean, apart from, let me see. You said he agreed to let you have the dog. Is that what you said, Julie?
Mm-hmm.
Okay, well, yeah.
But the agreement was that the dog would be returned back to her.
Right. And I mean, there's a little bit of vague language there, because I mean, he could return the dog after it's deceased, or he could return items of the dog. You see what I'm saying? So we don't know that.
Hey,
I'm trying to think through all the options here.
I got you. Go
This
ahead.
isn't legal advice, but I want to do a good job.
I appreciate it.
Right. So yes, you do have a legal remedy. You can seek to modify. But I mean, depending on the firm that you hire in order to go about this transaction, it's going to really depend on your rate of success.
So a dog is treated just like a car, right? In a divorce. That's the way we handle it.
See,
I've never in any of my inventories included the value of a dog.
dogs can be very expensive.
I don't think you could value the dog.
Yeah. I mean, some of these breeders, man, they charge top dollar.
Yeah, you pay $5,000-6,000 for a dog. That should be on an inventory.
I mean, I hear you, but the dog's worth so much more. It's an emotional value. You can't place that on a dog.
No. Piece of property, according to James.
And according to the state of Texas, but it's wrong.
Whoa. Easy there.
You could, I mean, this person could trade their child for the dog. I would do that. I'd trade my kids for a dog. No, but if it's a piece of property, you could do, because she said it wasn't mentioned in the decree, right? Which means we now have a piece of community property, presuming that it was purchased during the marriage, a piece of community property that was not divided in the decree. So we could do a post-dissolution division of community property. I don't know.
I think that's actually right.
Oh, it's getting creative. All right.
I mean, I think that's the thing though, because it says it's verbal. It's not in the paperwork anywhere.
I thought you said there was an agreement. Hold on one second.
Then an
There's
agreement.
a verbal agreement.
Oh, okay. Okay. Well,
We need to try that one day,
yeah, okay.
because nobody puts dogs in the decrees. James, that's your mission. You find us a post-dissolution to bring for
Okay. All right.
do a pro
If
bono.
anybody's watching.
All right. Shoot. All right. When we get flagged by PETA, we'll see something funny. All right. All right. You ready for the next question? Y'all took it far.
Yeah, let's go.
Okay. Let's give Floyd one. How do I obtain a divorce in Jamaica if I don't know the address to serve the divorce document? I have not seen my spouse since, and spouse is in quotation marks. I have not seen my spouse since
No, it's in
2018.
quotation mark 1.
Okay, yes. Thank you for that, Floyd.
Welcome.
I have not seen my spouse since 2018. The address I had for him no longer lived there. What do you see? Just for a moment.
You big question.
Some of these questions are written in a format for where the reader is reading them. An audience may question that reader's ability to read. So I would just like to formally express to everyone who is listening that I do have a formal education, and the public schools I went to did an excellent job. I'm gonna try this one more time. I have not seen my spouse since 2018. The address I had for him, he no longer lives at. What to do if the files for divorce, when I don't have an address to serve him the divorce petition?
So I think this person wants to know how to file for divorce in Jamaica if she doesn't have an address for him. So I hear that there's this live podcast with Jamaican attorneys. Might be able to get. I have no idea in Jamaica how to file for divorce. Um, I can tell you here if you wanted to file for divorce here. As long as one of you, lives in the state of Texas for 6 months and in the same county for 90 days, you file in Texas. I don't know if Jamaica has the same rules or not. Don't have an address for them. So you could do publication by service by publication, which is basically where you explain to the court, hey, I haven't seen him, I don't know where he is, that kind of thing. And then they let you post. So it used to be in a newspaper, you'd have to post an ad in the paper. Now you can post it online. And then that's deemed to be notice. And then you get the divorce, even without knowing his address. Again, this is in Texas, not Jamaica. You're gonna have to watch the Jamaican Attorneys podcast to get that information.
I don't think that's what she's asking. I think she's asking specifically about Jamaica.
She may be, and she needs to watch the Jamaican podcast to find out about that. We do it in Jamaican at 3:00. We go over the Jamaica stuff. So log back in. I don't know about Jamaica, but in Texas, I can tell you. So in Texas, 6 months, 90 days, then you could file here. Doesn't say whether there's kids. I'm going to presume no kids. She doesn't say anything about kids.
Didn't say anything about kids.
Yeah. And if you file in Texas, here's your solution. Move to Texas, live here for 6 months, in the same county for 90 days, and then we'll serve them by publication. If you have any property in Jamaica, I can't do anything about it. I can get you divorced. I can't give you any property. I can't get any obligations on him because I don't have personal jurisdiction over him. But Texas would then have jurisdiction over the divorce, and I could get you the divorce. Now you don't have to watch a set 3.
Log line.
Just come to Texas.
Come to Texas. Okay.
All right.
Okay, so there's anything else on Jamaica, Texas, divorces, how they differ, whether they're the same? You think they have random drug testing in Jamaica in SAPSR orders?
I seriously doubt it actually in Jamaica, but I don't know.
James?
No faith in yours.
I'd be surprised.
Sarabia.
All right.
Texas isn't a country. Sarabia, it's a state. It's one of the states in the United States, which is the country. Sarabia doesn't understand.
What was the question?
He said Texas is the best country in the world. It's not actually a country. Okay, we'll add that to your trilogy, Sarabia.
And history lessons.
Yeah. Okay.
Right. You want this one?
Can I still file for child support? Is that where we're at?
Yep. Can I still file for child support if my 18-year-old child is still in high school? My child turned 18 in March. I never filed for child support because his father was always working under the table. Can I still file right now while he is still in high school and collect current support and back owed child support until he graduates high school?
That is cruel.
Oh.
You can file. You can file for sure, as long as he's still in high school. You could probably get 4 years of back child support, but you're probably not going to get 18 years of back child support. And by the time you get to court, I presume your child would graduate in May. It'll probably be all retroactive support at that point. But yeah, you can file, and you'll have to go back and figure out what he was making, which is going to be your problem. It was your problem to begin with. It's going to continue to be your problem. If you can't prove what he's making, they're going to base it on minimum wage, which is $250 a month, $256 a month, or something along those lines. And you'll get a judgment for retroactive support. I don't know, maybe $10,000 or something. And then he'll have to pay that back to you in monthly installments. But yeah, you can file. You can file. It's still right. Still right.
Yeah, that's good.
Floyd would rather have the dog case.
I would much rather have it. James.
Yeah, I feel like you feel a little sorry for this guy. I don't know.
I mean, he should have been providing support, right? But she should have brought the case. You can't wait 18 years and then come in and say, here, now you owe me $391,000 or something like that. It's crazy.
Maybe morally not, but legally, yes, you can.
Maybe. So she has a chance, right? So the presumption's 4 years. And I guess if he knew he was the father and wasn't providing support, maybe, God, that's terrible.
Said he was a carpenter, right?
No, this isn't Jesus. I know that you're.
No. It said he worked under the table. I mean,
Oh, so you thought he builds tables while he's
not a far reach.
Only the legs.
Yeah.
Yeah, he only works on the legs of the tables.
You know, working under the table. What am I supposed to think? All right.
Drug dealer?
Excuse me, but I don't immediately jump to illegal activity. Okay.
You will. It just hasn't happened yet.
It's supposed to be Friday. A good Friday at that.
So, yeah, I mean, she could get retroactive child support, retroactive medical support.
Mm-hmm.
I presume this guy hasn't been paying anything at all.
That's what it sounds like. You said she never went after him.
Yeah, I never filed.
I think the takeaway out of this is take the child support case when you can. Like, even if you can't prove his income, get something, right? And a lot of times, if you hire some good attorneys that do podcasts in both Texas and Jamaica, they can get records, right? And it's very difficult for everybody to cover up everything. So in order not to, I'm not going to give that advice, but basically, we can obtain documents and things like that and find the money that they're hiding or thinking that they're hiding. Or there's also, we could argue intentional underemployment or unemployment if he's saying that he's unemployed for 18 years, right? And maybe get it to, so with that, we could argue if we could establish that he is unemployed or underemployed for the purposes of avoiding child support, then we could ask the court to base child support on his earning ability rather than what he's actually earning. The point is bring the case, right? Early on, that's your best chance to get all this. You would be very sad to go now and figure out that you waived 14 years of child support because, James, what's the math on that? You're the math guy. $256 times 14 years. You have no clue.
My computer froze right as you were telling me the numbers.
Right, I understand. Okay. It's a lot of money. So I think, yeah, do it, give it a shot, hire a good attorney because they're going to have to go back a long ways and go through a lot of documents and it's going to be very expensive. It would have been a lot cheaper to bring this case 15 or 16 years ago.
And if money was the issue with you bringing the case, you can always go to the AG.
You can. What's the problem with AG?
They don't work on much else besides well, that's not true. Let me not say that. They have a lot of roles, but when it comes to child support, that's what they're going to look at specifically.
Yeah, and they're really busy, right? They're funded by the state, so their funding is limited. They have a lot of cases. We can generally do things quicker than the Attorney General can. And I don't know that I've ever seen an Attorney General argue under or unemployment. And I don't think an Attorney General is going to go through bank records and all that stuff to try to establish what he was making. Right. So if we're talking about you giving up, $70,000 and you hire a private attorney for $10,000 or $15,000, might be worth the money. Good investment. Unless the attorney is not any good and you lose all of the 70 plus to 10 or 15,000. But I don't know any attorneys like that. So, anything else? We good?
I think we're good.
Okay. All right. Well, then let's wrap this thing up then. So we didn't say it in the middle, guys. Y'all didn't run me. Oh, James said it. It's not legal advice. You said it. Thank you. Right. So now it's the end where we're going to say nothing we said here today is legal advice. Every fact situation is different. And so a lot of times what we do or say depends on the facts. And sometimes the country, right? So
Very fact specific.
right. So if you have any legal issues like this, family law, then you need to hire somebody that practices family law in the area where your case is. Reach out to a good attorney that can assist you with the case. Point is, hire somebody if you need somebody. All right. You guys have a good weekend.